Good evening, this is Rahul Reddy. We are here live from Houston, Texas, like every Tuesday at 5 p.m. Central Time. We're going to discuss about the immigration updates. Emily, what do we have to discuss today?
All right, we want to talk to you about these weird notice of intent to deny people have started receiving from the El Paso field office of all places about pending 485s. And if you get one of those, why are you getting it and what you should do about it to make sure it's answered properly. And we often get questions about utilizing a visa stamp that has your old employer's name on it from a prior petition or prior job. And so we want to discuss whether you can use that visa to travel, if you need to take any additional action before you travel. We also are hearing lots of reports of strange things happening with CBP for people who are trying to get their H-4, particularly I-94, extended so that they can qualify for the 540-day auto extension of the EAD. This is often happening in Laredo. There seems to be a lot of forums that are talking about going there, and we want to guide you on how to make sure you're doing this correctly so that you don't run into any strange situations or problems and end up kind of undoing your extension that you just received. Another common question we're getting right now is my AOS is still pending. We know, the visas are likely to run out by the end of September. I want to get mine adjudicated. What else should I be doing? We'll talk about options for that and what you possibly could do to help ensure that you can get your approval by September 30th. And lastly, should you be using an agent to book your consular appointment for visa stamping? As you know, it's very difficult to get those appointments right now, so some people have been resorting to using these agents. Are these legal? Is this going to be a problem? So we'll talk about that a little bit.
And did you said El Paso? El Paso, that's right in the, is it Ciudad Juarez or El Paso?
Right, yeah, this is coming from the El Paso field office for people that are not routed to El Paso.
Wait. Most of our clients or none of our clients are there in El Paso. Why are we getting the RFEs from there?
Yeah, I mean, the good thing is it's for 485s where the case has been transferred to the National Benefit Center or was originally filed there. They're utilizing field offices all across the country in order to try to speed up the adjudication and get these cases approved so we don't have another thousands of green cards wasted, which is great. So a lot of times people are getting their case transferred to any field office.
Yeah, particularly I've seen Florida
from.
And also to Los Angeles office. Mm-hmm. And now we see that El Paso office seems to be that they have some officers who are willing to adjudicate the 485 application. With the tremendous pressure, the Congress has built it, and our clients have written letters to the USCIS, to the Congressmen, to the Ombudsmen and the USCIS director. They really want to adjudicate it. They put a lot of pressure on these people. But when I look into the RFE, Emily, and this is a situation where people are, not an RFE, notice of intent to deny. And in this notice of intent to deny, what they are saying is that your EB3 is backlogged, your EB2 is current. If you don't, they're practically threatening that if you don't use the EB2, they're going to deny it. And the problem with our clients is if they are with the existing employer who has already filed the EB2 and now they downgraded the EB3, that's not a problem. They're going to file the downgrade application and send the 485G supplement. But most of these people have actually moved out of the company, or some of these moved out of the company. Some of the situations, I believe, where they never have an EB2 when they filed with this particular company. The EB2 was with the old company. What do they do in that scenario, though?
Yeah, so the most important thing is when you're responding back and you don't have the ability to use the EB2 approval because you're not with that company or the company no longer exists or whatever the reason is, make it clear that USCIS does not have the authority to deny the 485 for not using the EB2. All they need to do is put the case on hold due to the retrogression in EB3 and adjudicate it when the green card becomes available in EB3, but they should not be denying it. And you need to make sure that that point is addressed in your response, because if you're just responding back, hey, keep me in EB3, and you don't tell them, by the way, you're not allowed to deny for this, they might deny.
Yeah, I want you to point out that you put them the 485 receipt notice. You give them the visa bulletin from the USCIS office and also from the State Department and point out, hey, you dummy, When I filed the 485, the priority date was current. Here, look at it. In the State Department, in the USCIS website, it says that the date of filing, they're going to accept it. So you cannot deny it. So please point out in the RFE response. Now, after doing that, I would strongly suggest that if your old company that has an EB2 approval, if they can cooperate, they can still file the 485J supplement and get you the green card approval. That's the first proposal that I would do. The second one is that if the previous company that has the I-140 approval is not cooperating, you can have your current company file a 485J supplement with EB2 of the previous company. There's nothing wrong with it. Now, a lot of people ask, how can they do the EB2 of the previous company? We thought that way too. But the USCIS opened our eyes. They have an authority to approve with the previous company's I-140 approval. Believe me, they opened our eyes. Maybe because of the pressure that you build, they want all 280,000 green cards to be approved. Could be the reason. They opened up the eyes that they have the authority to do so. And when your current employer says that, how can I use the EB2? You can answer to them, look, when you file the 485J supplement, you need to put the I-140 approval notice there. They will ask a question, the I-485 page 1, at the right bottom corner, they ask you, does this employee has an I-140 approval? So employers will answer yes. Can you give the 485 I-140 approval number? They are giving the EB3. Instead of giving EB3, they should just give the EB2 and then send it. Boom, your green card most probably will be approved before September 30th. Now, if they still don't want to do that, we still want them to respond them, because since the USCIS is asking the 485J supplement, you better respond with the 485J supplement. They can give the EB3 I-140 approval notice there. On a separate note, you can send to USCIS, look, this is not the employer writing, this is an employee writing. I have an EB2 approval and I want to use that for my 485 approval. You can send a separate note. Now, in the order, previous employer, first chance with the EB2. The second option would be current employer using the EB2 approval of the previous company. That is the second choice. The third choice is the company filing the 485J with EB3 with a private note to the USCIS office. And if they don't accept all these three things, you give the fourth choice, let the respond to the USCIS, as Emily pointed out, to write not to deny the 485. And you can send a separate note privately to the USCIS. I see a lot of question. If I'm forced to upgrade to EB2, what are the things necessary? You can make an appointment, guys. I'll be willing to give you the drafts of it, what you need to, the cover letter, what you need to. I will say, you can make an appointment with me or Emily. We'll give you the draft of it, and you can do it by yourself, or if you want to contact us, we can do it by ourselves. We can do that. Anything else, Emily, on this field office, though?
Nope, I think that is it for now. So next up is the visa stamp in your passport. If you, for example, received an H-1B approval with company A, you had the visa stamp with company A, now you've transferred to company B, but company A's visa stamp has not yet expired. Can you use that to travel?
Yes, Emily. First note is that here is the company A, H-1B has not been expired in the passport stamping. So let's say that company A's H-1B stamping is expiring in September of 2023. But now I move to company B. Now my H-1B is expiring in September of 2024. But the passport visa is expiring in September 2023. Now, since there is a lot of problem in getting the appointments, you can travel before September 2023. That is because your passport visa has not expired with the previous company. And when you go outside the country, you can come back, but make sure that you show them the passport stamping of company A. Tell them that you are not working for company A, you're working for company B. Show them the H-1B approval of the company B's H-1B, and you get an I-94 until company B's H-1B expiring, which should be September 2024. And as soon as you come into the country, check online to make sure that your I-94 is expiring in September 2024. Don't look online in October of 2023 and then find out at that time you have an I-94 until September 2023. You will be in big trouble. If you notice that by any chance that happens about 2 to 3% of the time that your I-94 is only until September 2023, please contact a lawyer. Don't go to CBP office, contact a lawyer. There are different ways of correcting that. Don't go to CBP office. That will be the next topic for us. And what if, Emily, I have company A stamping until September 2023. I move to company B, my H1B is expiring in September 2024. Then I move to company C and my H1B is expiring in January of 2025. Can I still travel with company A's H1B approval, passport stamping?
Yeah, even though you've transferred multiple times, the visa itself, the stamp that's in the passport, remains valid either until it actually expires or it's revoked. And it doesn't get revoked like a petition does when you leave the company. So that visa stamp remains valid. You can continue to use it as long as you are coming in for the same visa category, even though it's a different company.
What if I got a H1B with Infosys and I got the stamping in India, which is expiring in October of 2024, and I never ever came to United States. Now I got the great offer with Apple, and when Apple can file H1B with the consular processing, do I need to go for stamping again? I'm in India, I never came to USA.
No, that visa is valid even though it has the Infosys.
I never came to USA.
Yep.
Oops. So what do I do? When I come in, I show them, here is the Infosys H1B approval, here is the Apple H1B, I'll be working for Apple. And make sure they get the I-94 for the Apple.
Right.
That's easy. Yep. Anything else, Emily, before we go to the next topic?
All right, next topic is a big one. We're hearing lots of issues with people who are going to CBP and asking them all kinds of odd requests that they're not used to being asked. For example, please extend my I-94 so that my wife can get her automatic EAD extension, or please correct my I-94. I should have been given this extension, and doing this by email to the deferred inspection site. And it's resulting in all kinds of strange things. And it's not always a good thing that it's happening. Sometimes they will change your I-94 end date to an old end date that you don't want. So you're really shooting yourself in the foot by doing this. So you have to be very careful about how you're approaching CBP with these kind of things. Do you have any examples, or do you want to discuss with that?
One thing, guys, when you walk into CBP's office, okay, you're walking in a lion's den. Be careful, okay? Now, there may be some people who may go to lion's den and steal the rabbit out of the mouth of the lion, and they will come and claim to you they did it. Maybe they did. We're not telling they did not. But be careful. These are some of the incidents that happened recently. One person has requested the CBP to extend the H4, which CBP cannot extend the H4. She went to the CBP office. Instead of extending the H4, they actually cut down the time based on her previous passport expiration when she entered the United States. So her H4 was expiring in September 2022. They cut it down to September 2021. Boom, she's now not in good shape. These are the instances. There are people who have walked into Laredo's CBP office requesting, give me the H4 extension. And there are some people who have been detained in Laredo, and I don't know why these people are going to Laredo, driving to Laredo. A lot of people are flying from New York and other locations and driving to Laredo. Don't do that. Get an advice of the lawyer before. There is also some situation where one guy took his dad to the CBP office when he thought that the I-94 was given for a period of 6 months, but when he realized online, because it's a B2, it was only given for 3 months, they took him, saying that after the I-94 expired, they took him to the CBP office, took an appointment, took it, and they detained the dad and sent him back. Because, hey, you're walking into Lion's Den telling that I am illegally present in this country. I mean, they don't have an option. They have to detain it. The rules tells that if somebody tells that they are completely illegal, walks into the den of the lion, of course they are going to detain them and then send them out of the country. So be careful when you do all these things. Any other things, Emily?
Yeah, we generally recommend, we know people are needing to get the extended I-94 of the H-4 based on the spouse's H-1B approval so that you can get the automatic EAD extension. That's generally what's causing a lot of this. But from the beginning, we've been telling people, don't do this by car, by walking across. We recommend traveling by air. Make sure when you're going there, you're going before your current visa expires.
Or I-94 in some
And the I-94 as well. And then stay there for a meaningful period of time. So go there for a vacation, go to a touristy area, go for a weekend in Cancun, Cozumel, have a margarita. We call it the margarita switch. And then come back by air so that you can present your valid visa and your I-797 approval notice of the H-1B spouse and be let in for the same period of time that's on that I-797 approval notice.
One other notice, Emily, is that when you are coming from India, whichever country you're coming from, always watch the I-94. There is a chance, and this is the biggest, easiest thing, biggest mistake, but at the same time easy to spot it out, is when you come into the country, please check your I-94. And because sometimes, most of the times, or sometimes, they only give the I-94 until your passport expires. Now, here is the situation. Let's say, for example, your H-1B is expiring in August of 2025. The US Consulate can stamp the passport even though your passport is expiring in January of 2023. They will still give you the stamping until January of 2025. So when you come into the country, the CBP will only give you until January of 2023. They may not give you until January of 2025. That means that if you don't do anything after January of 2023, you will be staying unlawfully in this country. There are negative consequences for it. If you notice that after January of 2023, you will be in great trouble. If you notice it before, there are some easy ways to correct it, but I still want you to go through the lawyer. Don't do it by yourself. There are ways you can do it going to Mexico. There are to India, depending on whichever country you want to go. Those are the best solutions, but always don't go to CBP office, guys. We do not recommend that. Anything else?
All right, next up, you know, we know everyone's 485 application adjustment of status has been pending, especially since October 2020 when we had the whole downgrade mess. And people have now upgraded or interfiled or refiled, and USCIS is adjudicating a lot more applications than they have been, but people are very impatient, rightly so, totally understand that. You want to know that you've done everything you can do to make sure yours is the one that gets approved by September 30th, because we know this is kind of a once in a lifetime opportunity or twice in a lifetime opportunity with the spillover from family-based. But at this point, we're so close to September 30th, USCIS has kind of gotten into a groove where they are definitely adjudicating more 485 applications than they ever have. They got the message, don't waste employment-based green cards this time around. So they are working to do that. So if at this point you are contacting them to follow up, contacting them to see if you've been moved back into EB2 after you did your interfile request, contacting them to see if your application's been moved to a field office, chatting with Emma, contacting your congressman, all of those things, you're going to end up with your whole application at the caboose of the train. They're going to pick up your file, look into it, answer your question, and then put you at the bottom of the pile. So you're actually kind of making things worse by doing different follow-ups so many times right now. So what can you do? Again, if you don't have your EB3 I-140 approved or your EB2 I-140 approved, get those upgraded in premium because they won't do anything until those are approved. If you haven't submitted your medical, make sure your medical gets submitted. If you have not interfiled yet and you're eligible, make sure you're doing that. And then keep quiet and wait. Let it
upgrade to EB3 to EB2 if you have not done that. And medical RFE, you can interfile it without them issuing it. We're getting a lot of consultations. Please don't contact us, guys. Don't pay us the consultations money just to ask how to expedite the case. How can I move my case to the NBC? How can I get my case has been moved 4 months in NBC, it's still pending there. Is there any way we can get you the green card? We already suggested what can be done. That's all we can do. As Emily pointed out, the more you contact, it won't be of any help. If there is anything that we know it's going to help, we will tell you. Or if there is some steps to be done, we'll charge you the money to do it. But we are telling that if you contact us saying that please tell me how to expedite it other than what we told you right now, there is nothing there, and we don't have any special influence, and whoever tells you special influence, they're all wrong. Don't believe it. So please be patient, but do what we told, the certain step. EB3, I-140 approved, even though you refiled in EB2. Please do that thing. Medical interfile, do that thing. If you have not interfiled, if you have not refiled, and if you have not upgraded though, we strongly recommend you do that thing. Now, if your employer is not willing to upgrade, previous employer, current employer is not willing to upgrade, you may want to consider doing a self-upgrading process. Sometimes it works, sometimes it doesn't work. You can do that step if you want to, but otherwise don't contact the congressman. You'll get a standard response. It's in line. That's all they're going to say. Ombudsman, not needed. Expedited, there got to be extremely good reasons for expedited. For example, you are the only person who can lift the SpaceX rocket and your EAD is not approved, and then you need this GC EAD for some reason. There can be a reason. I mean, those are the reasons that I can think about. But otherwise, don't just try to ask them to expedite with not a good reason, and don't give any false information to USCIS that you want your case to be expedited. That's not good for you.
All right, last up that we wanted to talk about is this idea of using an agent to book your visa interview appointment at the consulate in India. Have you seen people successful with that? Or are we supposed to be doing that?
Well, let me explain, Emily, what's going on in India so you understand what. So when people are trying to book the appointments, so they're not available until they're not available, period. Not available, nowhere. So these people are resorting to go to the consultants that are charging about $300 to $500 per, and they are getting the appointment faster. How they are doing, what I was being told, I never encouraged it. I just got informed, I never encouraged it, is that these people probably are in front of the computer. They take the username of the person, they take the password of the person, and they are there, checking out, refreshing. All of a sudden they get it. They not only book to that guy, they probably have a lot of computers, they book all the other people though. The consulates are now discouraging it. They have already made statements on it. In the Facebook Live that they did it recently, that they're discouraging it. They have created some bots to avoid these kind of things. They may take action on these people. That's a fear that I have. They may, I'm not telling. There are some people who told that this is a rumor at this point of time, because Reddy and Neumann PC will not confirm anything until we speak with an individual by ourselves. Even if somebody puts a notice there, we contact the person. If it's something very rare, we speak with them. We want to see the document. When somebody said Laredo is issuing a RFE, I said, I want to see the RFE. The guy sent an RFE. I spoke with him, then I confirmed. Of course, then we got a lot more RFEs. So at this point of time, it's still a rumor that they're taking action, but we will confirm it as we go forward. But we strongly encourage at this point of time, do not book appointments. It has come to the notice of the consulate, and they may cancel, they may take action on you. Do not book appointments with these agents. Now, you can do the refreshing every day. I'm not telling they are doing it is wrong, but you doing a refreshing, it's nothing wrong with it.
All right, I think we can go to some questions. We have one from Bala from Facebook saying that he just got his H-1B extension that's valid until 2025, but he doesn't have that visa stamped in his passport yet. He just has the I-797 approval. He has a Canadian visitor visa and wants to know if he can travel to Canada by road and come back, even though he doesn't have the valid stamp in his passport, the visa stamp. Yes, there is a provision called automatic visa revalidation. It's only for travel to Canada or Mexico. You can only travel for less than 30 days and do not apply for a visa stamp in Canada or Mexico. In that situation, if you have the valid I-94 on your I-797 approval notice and an expired visa stamp, you can go into Canada less than 30 days and come back into the US and be given a new I-94 that matches your I-797 extension approval notice, even though you don't have a valid visa stamp.
Mohan Raj has this question. His priority date is April 2016. His son is becoming 21 by March of 2023. Is there anything I can do? His I-140 was processed in premium processing. Good. We have a solution which may work, but will not harm, but we need complete cooperation from your company. What we want you to do is withdraw your I-140 and file an I-140 again. Why? Because so that lawyers like Emily and me can make money. True, we do make money, there's no doubt about it, but we have a good reason for you to actually withdraw your I-140 and refile it. Mohan, you already identified that the I-140 has been approved in 2 weeks, and you know the Child Service Protection Act deducts the amount of time your I-140 is pending. So if you withdraw the I-140, you can file another I-140. You do not need to file a labor certification. You do not need to file a labor certification. You can use the labor certification that was approved maybe in April, maybe in 2016, and refile the I-140 again. And this time, your Texas Service Center in Nebraska is going to take ever, and you are not going to do premium processing this time, and it may take 1 to 2 years. So now, when does your son becomes 21? It's not going to be March 2023. It's going to be March 2025 if your I-140 is pending for 2 years instead of 2 weeks. You already know the CSPA rule. So if you can get the cooperation of the employer, make the immigration lawyer rich. I don't encourage people to make the immigration lawyer rich most of the times, but in this time, I do tell you to make him rich as well.
Debbie says, does the marriage certificate from an Indian consulate in Chicago, is that sufficient for the dependent's 485 filing with USCIS? They're married in India and don't have the marriage certificate issued in India. No, that won't be sufficient for actually receiving the green card. They don't accept those. If you don't have the time to get all of the documents needed, you can file the 485 with that, but you can expect to get a request for evidence asking for the actual marriage certificate from the government in India. If that is not available because there isn't one, then you need to get a non-availability certificate first. Then you get 2 affidavits from family, friends, or relatives that can confirm the details of the marriage, and those can be submitted instead of the one issued by the consulate.
DKR, can we write letters to the Senator about USCIS processing inefficiencies, random processing order, unreasonable processing time, too many pending packages, instead of just writing about GC visa utilization? You have a good question. I understand that people who filed in May 22nd or May 26th of 2022 got the green card, but the people who filed in October of 2020 did not get the green card. Same priority date, same everything. It's really unfair right now. Yes, you can write the letter about this one. I'm not sure at this point of time we have enough support so many people can write letters. And I don't know if USCIS chief is going to take action on it, but it's definitely, you have a point. You can write a letter.
Akshat says I had the October 2020 downgrade with a priority date in 2014. Interfiled in June. The file's been transferred to NBC and then transferred to the field office July 7th. Still in the field office. No update since then. Is there a chance to get the green card this year? Yeah, the difficulty is the field offices, they don't have a set processing time, and there's not a way that you can follow up with them. You can't contact the local office. All you can do is try an inquiry through the regular USCIS e-request or by calling the 1-800 number. But again, we don't recommend doing that right now because you don't want to delay your case further by being put at the back of the line. Yes, there's still a possibility to get the green card this year, assuming that your downgrade I-140 is approved. You obviously did the interfile already. Make sure that your medical exam has been submitted. If not, send that to the field office. Make sure those are the things that you can do to help ensure that you do get the approval by September 30th. But USCIS, as pointed out by the last person asking a question, they are not prioritizing based on when the filing date was. Unfortunately, they seem to be prioritizing which cases are easiest. So the ones,
and which cases are easiest in this?
Yeah, the ones where it's filed based on an already approved I-140, where the priority date is current at the time of filing, nothing where there was retrogression involved, nothing when there was a downgrade involved. The cases that went directly to the National Benefit Center, those are all the easy ones in their mind and can be easily and quickly approved, versus ones that have to be transferred, ones that need an I-140 approval first, ones that are missing the medical exam. So it is possible, but I wouldn't take any action to try to speed things up because you're likely going to slow things down.
A lot of people are asking that what are the timings of the NBC once it moves to NBC or field office? We can't tell. I mean, there are people who are getting approved in a very short period of time. There are people who have been transferred from past 4 or 5 months. They're still pending. It's very hard to tell. And unfortunately, there is no action that you can take to have them adjudicate, though. Shiva Krishna from YouTube has this question. I-140 withdrawn after 180 days, EB2. The current company that I'm working filed an I-140. Can I use the previous company's EB2 I-140 approval to file the 485 with the current company's EB3? No, you cannot do that, Shiva Krishna. The other thing that I would suggest to you, Shiva Krishna, is if you can contact the previous company which has withdrawn the I-140, they can refile the I-140 and file the 485 for you. That solution is there. That's one. Second thing is that with the current company, I don't know if the labor certification has been filed under EB2 or EB3. If they're filed under EB3, you don't have an option. You may want to have the current company file an EB2 labor again. But if they have filed under EB2, they can file one more I-140 and file the 485. But most likely, it seems that the current company might have filed labor certification under EB3 for you. So the best option for you to file the 485 immediately is to contact the previous company that had the I-140 approval.
SD says, I have my EB2 I-140 approved with my current employer for Texas, but I moved to Maryland in July with the same employer. What are my options if my date becomes current in October? I think it depends on the situation regarding the move. If the job that was in Texas, it would still be available to you to move back to when you get your green card, you can proceed to file the 485 when your date is current. And with the intention that you would move back to Texas when you get your green card. So that would be the easiest option. If the job change in location was permanent, then you're looking at having the new company file a new labor filing a new labor certification for the new work location. That's going to take 18 to 24 months to happen. So you're not going to be able to file your 485 until you get that labor certification approved. So it's definitely going to be a major delay. And you also have to be aware of, once your priority date is current, you are not able to keep getting the 3-year extensions of your H-1B. You can only get the 1-year extension of your H-1B. So keep that in mind as well.
Nitin, refiled and got GC, got EB2 EAD without AP. Yeah, we are noticing some of the EAD approvals without advance parole, though. Please, when you travel, make sure that you have an advance parole. One other indication that I will tell is that if people are getting EAD and advance parole, especially the refiled applicants, that is not a good sign. The reason is that most of the cases that we refiled though, they're just getting approved straight without any EAD and AP. So when they are adjudicating EAD and AP, that means that there may be some delay in your application, but unfortunately there is nothing you can do. Emily, what about all the people who said if you refile, they're going to deny the application and all those things? What happened to those things, Emily?
Yeah, luckily none of that happened, as we predicted that it wasn't going to happen. There's never been any restriction on filing more than one 485 as long as you have a grounds.
And the USCIS in its website said that they are not going to get preference. Did they went with that?
No, that's not even right. Yeah, they definitely gave preference to the applications that were filed later, which happened to be many, many refiled applications.
Not that we like it, guys. We just, it's just a process. When we are representing the clients, it's not, they are our guard. I mean, we have to see what is in their best interest. Society is not our client. The client is our client. Society is not. We do presentation here, but when we represent a client, he is the guard for us. I mean, we have to see whatever is the best interest of the client. We have to, in that best interest, we did suggest refiling, and it did work out. Even the USCIS said, don't refile, they did not encourage it. A lot of lawyers refused to refile, and we said it's perfectly legal to refile. And a lot of people got the benefits, and wish you best of luck, guys.
Bhupinder says, is there a chance the cases transferred to the NBC will be adjudicated? We are seeing cases that are transferred to the NBC getting adjudicated. We do publish that information. I did get a chance to update it today. If you go to immigrationgirl.com, there's a blog post there that has all the details of the 485s that one of our attorneys in our office is receiving. So you can see exactly where it was filed, when it was filed, what the priority date is, which service center it started at, was it transferred, was there a refile, was there an interfile, was it a downgrade, when it was transferred to the NBC, and then when it was approved. So with all of that data, generally, assuming that the medical was taken care of, assuming that there's the downgrade I-140 is approved, the EB2 I-140 is approved, most of the cases that are getting transferred, we're seeing approvals in about 70 days on average to the time, 72 days from the time it gets transferred to the NBC to the time it's getting approved. So yes, there's definitely chances that that will continue to happen. Anoop says, my priority date is June 2012. What will happen if I don't get the GC before the end of this fiscal year? My cases are still pending at the NBC since January. So you just automatically roll over to the next fiscal year. Your 485 continues to be pending, and they will assign a visa number to it out of next year's cap, assuming that everything is ready to be processed, and it just continues to be pending until they actually assign the green card to it. Unless the date retrogresses, if that happens and your date is no longer current, which I wouldn't expect since you're in 2012, but when that happens, then they just put your case on hold. They continue to renew the EAD and AP until the green card becomes available again. So everything just gets put on hold and then processed later.
Can we go for H4 visa stamping with the H1B to the home country, even if the stamping is valid for 9 months? That means that you already have a H1B stamp for the next 9 months. Can you go for H4 visa stamping? Absolutely, you can. There's no problem with it. If the employment, Rajan Soni, if the employment-based green card gets approved while an India trip, can we come back and advance parole as planned before? You can, absolutely, never a problem. However, when you come to the airport though, they may take you to a small room. Don't get scared with that. You're going to stay there just for 15 minutes. They'll verify everything is okay with you. But we never had any problem in entering into the United States if the people have got the green card and they were trying to come on advance parole.
Nikhil says, can we upgrade from EB2 to EB1? Assuming that you qualify for one of the EB1 categories, absolutely, that can be done. And you can retain the priority date from the EB2 approval and assign that to your EB1 approval. And then once you have the EB1 approval, you can either interfile that and request to transfer the underlying basis from EB2 to EB1 for your pending 485, or you can file another 485 in EB1 since that date is current. So yeah, there's no restrictions on that at all.
VC Kanaparthi got the 485J receipt notice. It's from NBC. Does it mean that is it assigned to the field office in Missouri? No. In Missouri, Lisa, the answer is no. We cannot assume that it's been assigned to an officer, but definitely things are moving in your favor. Minnote 100 got an interview call. Should he be worried about? No, we are noticing approximately around 5 to 10% of the people are getting the interview notices. I would definitely have a lawyer mock interview you. And to mock interview you, when you make an appointment with the lawyer, try to give him the labor certification approval if you have. And if you have the 485 application, it will become easier for them to interview you and your spouse if you have one, who are going to go to the interview. We also put a we also put a AOS interview, what questions they ask, how you should dress, what time you need to go. Will you be sitting on the left chair or the right chair? We have given a description to you in so detail, because it will be on the opposite side of the monitor. You will be sitting, the main applicant. We have given very detailed description. You can watch that in the YouTube at Reddy Neumann and AOS interview. You can watch that interview. You can watch that to just get a little bit idea for it. And when somebody does consult me with a mock interview though, I normally send them, these are the questions that the USCIS officer will ask, and I'll give them the interview, the AOS, the 10-minute thing, YouTube link, and then I speak with them because they are well prepared when they speak with me for the mock interview. That's what I do normally.
Shashank says, my 485 is pending with the Texas Service Center. Supplement J was submitted to the National Benefits Center. Where should I interfile my medical? To Texas or NBC? So you need to send it to the Service Center where your 485 is actually pending. So if it is still at the Texas Service Center, that's where you'll need to do the interfile of the medical, regardless of the fact that the 485J came from the National Benefits Center.
Deborah has this question. Does intent to deny mean that my adjustment of status is denied? No, absolutely not. We definitely do not want you to respond. We want a lawyer to respond to the RFE. We are seeing this weird intent to deny, especially coming from the El Paso office, which seems to be that, El Paso, they don't understand employment-based immigration. No H-1B goes to El Paso, I guess. I've been to that town. So that's the reason they definitely are not familiar with it. In fact, I went to the USCIS office for an interview there once, to the El Paso. They are definitely not familiar with the adjustment of status of the employment. And we are seeing that weird RFEs, but we definitely do not want you to respond to it, have a lawyer respond to it.
Abhishek says, I'm hearing that you can file a family-based F2A for your dependent, even if the dependent already has the AOS employment-based 485. Is this possible? Yes, it may be possible. So this would be the situation where the main applicant's 485 gets approved, the dependent is still pending. So the main applicant is now a green card holder, but the dependent has a pending 485. So you can file an I-130 under the F2A category as for the spouse of a green card holder. The ability to file another 485, though, depends on whether your dependent continued to maintain their own non-immigrant status up to the time of filing the new 485. So if your dependent was on a dependent visa, like an H4, and you got your green card as the main applicant, that puts the dependent out of H4 status because there's no H1B anymore. In that situation, filing another 485 is not possible if the person has failed to maintain that H4 status for 180 days or more since you received your green card.
Why not risk? When forced to file TUB, what he meant TUB is transfer of underlying basis by ourselves, do we need to send it to California or local field office where the application is residing? We want you to send where your application is residing. California address is only used to get the 485J supplement, and when you do self-doing the upgrade, though, you don't send any 485J supplement. So do not send it to the California, send it to the field office.
Priyanka says, our 485 was filed 1 week ago. The company lawyers didn't ask for the medical with our application.
Wow.
What should we do to avoid the RFE and submit the medical? So you can definitely go ahead and get it now. I will say the NBC is pretty quick about sending the RFE for the medical. I've seen many that come within 1 to 2 months after filing the 485. So you could get the medical done, maybe hang on to it for a month or two to see if you get that RFE. If not, go ahead and do an interfile of it. We have instructions at rnlawgroup.com. If you do a search there for interfile medical exam, it tells you exactly what you need to submit and how to submit it so that you can get it into the file.
Bobby Thomas, my date of birth in my passport and birth certificate is different. Can it affect my 485 application? Yes, it will. Is the date of birth on a birth certificate wrong, or is it passport wrong? You need to figure it out which one it is. If you can correct the date of birth certificate, that will solve it. If not, if the birth certificate is right and entire, your passport, your visa, your H1B, your everything is wrong, from your school certificate, everything is wrong. There are ways to correct it from scratch all over again, all the way from passport all over again. But I would definitely recommend to contact. I may be a better lawyer because I'm a lawyer in India and here in USA too. You may want to consult a lawyer to correct it.
Div says my I-140 for the EB3 downgrade is complete and submitted the supplement J for EB2 in March. Everything's at the NBC. Should we send the medicals now or wait? That's one of the few things that you actually have control over, so I don't see any reason not to submit it through the interfile to the National Benefit Center, assuming that's where your 485 is pending. If you have not gotten the medical yet, you can ask the doctor to give you multiple originals so that you can send one to NBC, and in case it doesn't make it into your file and you still get an RFE, you have another one ready to submit in response to that RFE.
Rahul Jain, he has a very good first name. Got his GC, but they printed incorrect date of birth. What can I do? You can file something called I-90 form. Unfortunately, you will have to give up your green card, and when you file the I-9 form, you send the green card with the I-9, sorry, not I-9, I-90. Sorry, I-90, sorry, not I-9. And you have to give up the green card. They may take a long time to send a proper green card back to you, Rahul. The best solution would be that while you are waiting for the green card to be issued to you, with the I-90 receipt notice, you can go to the USCIS, local USCIS office, and before you go to local USCIS office, you need to make it an InfoPass, INFOPASS, InfoPass appointment, and they will stamp your passport saying that Rahul got his green card. Then you can use that as a green card. You can use that even to travel outside the country and come back.
Go-Rob says, my I-140 was initially filed in EB2, got it downgraded to EB3, and the priority date is July 2015. You want to know if that gets current in the filing or the final action date chart. Can I use the previous I-140 that was filed in EB2? So assuming that you're still with the same company that has the EB2 approval, or that company is still supporting you if you've left that company and moved on to another, yes, you do have a couple of options, which is kind of what everyone's been going through for the last several months. You can take your, so you do have the option of filing the 485 based on the EB2, assuming that that company and that job offer remain available even after it got downgraded, assuming that it was not an amendment that was filed to do the downgrade. It should have been a new petition for the downgrade.
Palak Arora from YouTube has this question: can I travel on advance parole and continue to work on my H4 EAD upon return to USA? Do I have to take any action for this? Palak, what they're telling us, the USCIS is telling us, when you travel on AP, especially when you're on H1B or L1 or L2, H4, they are telling that you are still considered to be on a non-immigrant visa once you come back. And they are extending the H1Bs, they're extending the L1s, they're extending the H4. So because they are saying that thing, I would say you can work on H4 EAD and there's no action required as long as you have the H4 EAD with you.
Sambit says, are there any options for applicants of the H4 and H4 EAD where the H1B has been approved and the rest of them have been processing for more than 6 months? Is there any way to get the approval faster? At this point, the main way to get the approval faster for the H4 and EAD is to do an expedite request. There are very limited criteria that allow you to do an expedite request. For example, if you're a healthcare worker, they do have a special category for that for an expedite. Other than that, it's got to be severe financial consequences, which generally does not work in my experience for an H-4 EAD expedite. If you are working in some very important project and your company is going to lose a bunch of money because you have to stop working, if your company supports, you can provide a letter from the company explaining the situation and asks for an expedite that way. But it's all very difficult to get an expedite to go through. It's hit or miss. USCIS generally says, we know processing times are bad and there's nothing we can do. We can't expedite everybody, so we're going to expedite no one. So beyond that, there really isn't much that can be done right now.
Infosys has this question: after receiving the green card, how long can I stay out of USA? Wow, you got the green card, you want to go outside the country. That's what happened with me. When I got my green card, next day I booked my tickets to India. Now here's the thing. If you're staying more than 6 months though, I definitely want you to consult a lawyer. But if you are staying within 6 months, you're going and come back, go and come back, you're good, no problem.
Anil says the dependents have the approved H-4 based on a previous employer that's valid till next year. The H-1 petition from the current employer expires later and wants to know if the priority date becomes current, do I need to file and extend those H-4s? So the H-4 itself is not actually tied to a specific employer, even though it was filed based on your H-1B with that particular employer. So it remains valid even though you've changed employers, but it does expire earlier than your H-1B. So as long as their H-4 does not expire at the time before you're filing the 485, there's no need for you to extend it to be able to do that. Just make sure that you file the extension before their H-4 expires, since it does have a different end date than your H-1.
Sandeep, what happens if the employer changes a physical location while filing a permanent AOS? Sandeep, the main thing is that, is it out of the same MSA, or if it is within a reasonable driving distance, or also called as MSA, but also within a reasonable driving distance, that's not a problem. But if it's like 200 miles, definitely there is there is something that is a concern. If the company has moved its location, you may want to consult a lawyer though. Question from Amit: how soon can I leave my employer once I get the green card in hand? The same day. I don't know why people are getting these rumors or articles saying that if you leave within 6 months, your green card will be cancelled, your naturalization will not be given. Show me one case. Nothing happened. Nothing is there in the USCIS website. Nothing is there in any of the website though. And of course, there is a memo from USCIS that clearly says that it is the job offer, not the job by itself, whether you're doing the job itself, that is getting you the green card. So you can change as soon as possible. We have had no problems, none whatsoever at all.
Adil says, I responded to an RFE for the 485J back in June with the Charleston field office, and I did a congressional inquiry and received a response that my case is under adjudicative review. Any information on that? Adjudicative review is the same thing as that you're just in line, waiting to be processed by the officer. It doesn't mean they're actually doing anything at the moment. It's just in process, and there's really not anything else that you can do at this point except for wait.
Neeraj Housa's question: he received his green card. What happens to the H-4 extension and EAD extension? Well, there is a good chance they may deny it. That's fine. You will not have any negative effect on you. And some of the times they even approve the H-4 EADs, but you can ignore the H-4 EAD. Believe me, I don't know if you know the case of Muhammad Atta, and if you guys don't know who that guy is, believe me, he is the cause for a lot of us suffering because of the strict immigration rules. He is the guy who was the architect for September 11, 2001. You know, the one who went to the Twin Towers and the flights, the terrorist guy. Guess what happened to his M1 visa that he applied when he came on a B2? He applied an M1 visa. After the guy died, 2 years later on, after September 11, and this guy is the number one, almost number one terrorist, they approved his M1 visa. That happened. Now, in your case, though, they should not approve the H4 EAD. They should not approve the H4 and H4 EAD. They should deny it because you're not eligible. You're a green card holder. But if sometimes they do this still. If they do it, just ignore it. You're fine. You have the green card. You don't have to do anything.
BJ says, how many times can one use the automatic revalidation technique? Let's say I have an I-94 valid till 2025. Can I use it and visit Mexico twice? Absolutely. There's no limit on that. As long as each trip is less than 30 days and you're not applying for a visa while you're there and you have the valid I-94, you can travel multiple times within that validity period.
I know some people who use 100 times a year MD. They actually stay in the Detroit. What's the border of that town?
Windsor, yeah.
Windsor, yeah. You know better. You're from Detroit. Yeah, they stay there and keep coming here and working in Detroit and going back. Anything else, Andrew? Okay.
Yeah, I think we are getting a lot of repeat questions. A lot of people asking kind of what's next for the 485 after you've responded to an RFE or after it's at field office or after you've submitted your medical and all those things. Again, there's, you know, assuming all your I-140s are approved, you've submitted your medical, you've done the interfile if you're eligible, there's really not much more you can do. And by following up constantly and contacting USCIS on your case, you're actually probably likely to slow things down. So at this point, we need to let USCIS do their work and not bother them and just wait and, you know.
Do not make a consultation with our office just to ask the prediction of the priority date, guys. I mean, we will tell you our estimate, but don't pay the money to us and just ask and keep asking what's the priority date, please. You know, that's you're not going to be fruitful. That money will be wasted, I will tell you.
All right, well, thank you so much for joining us. We'll be back next week on Tuesday, as usual, and please make sure that you are subscribed to our newsletter. You can do that by going to rnlawgroup.com, and you can also subscribe to immigrationgirl.com, where you can see the latest updates on all of the 485 approvals that we've been seeing in our office.